is crucial in understanding what I'm talking about with respect to challenging the jurisdiction of the court. The judicial power of the Commonwealth shall be vested in a federal Supreme Court to be called the High Court of Australia, and this is the important part, and in such other federal courts as the Parliament creates. Okay? Every single court in this country, when requested, must first and foremost abide by Chapter 3 of our Constitution. If it says, I'm under the state regulations or I'm under the Magistrates Court Act, okay, let's go to section 100. Here we go. Because you're being dragged in under an infringement notice, then it falls under the heading of a civil jurisdiction. Now, if you're in a magistrate's court, you would ask the magistrate to ignore section 100 of his act.
Which act is that?
Magistrates Court Act 1989. Okay? You ignore section 100 of this act. Why? Because section 100 says the extent of jurisdiction. The court has jurisdiction to subsection 2. The court does not have any jurisdiction in any cause of action with respect to any royal prerogative.
Every clause 5 in the Constitution Act.
Do we understand what I've just read out?
No.
Royal prerogative. Royal prerogative. Okay? So it's just saying we're not under the Constitution, the laws of England, or anything that comes out of those laws. That's outside of our jurisdiction.
That's what the judge would say.
That's why the judge can say, well, no, we only hear, this is a state court, and this is all we're here to address. Peter has been in over the last couple of weeks into the Supreme Court to try and have this section rubbed out, because it shouldn't be there. Again, we come back to section 15A, Acts Interpretation Act. How the hell can this possibly have been drafted by our Attorney General when it is in total contradiction with our constitutional rights? So,
is this many, what do you call you've got a word written there, it's inconsistency.
yeah, inconsistent. It's an inconsistency.
That is full of inconsistencies.
It is. So, if we're in under, say, for instance, the Road Safety Act, then we're challenging this. We're challenging the Courts Act. Okay? We're here to give that magistrate a hard time. Okay? Now,
and it's good fun, I can tell you.
It is good fun. Now, we have...
But what is the outcome at the end when Peter...
Well, what we do usually is, because we are subjects to the rule of law under the Constitution, we then cite Section 3 of the Supreme Court Procedure Act, New South Wales, Supreme Court Procedure Act, New South Wales, 1900. Now, Section 3 says there must be consent from both parties.
Mr. O'Brien.
Here we go. Bingo. Thought we had it. In any action by consent of both parties, in any action, doesn't matter whether it's civil, criminal, whatever, there has to be consent. Now, when you read this section, you read in...
What section is it?
Section 3. Okay? of the Supreme Court Procedure Act 1900, New South Wales. Now that applies here. Why does it apply here?
Section 118.
118, that's right. Linda?
You can go top.
Actually got in your hand. They both been assented properly by the Queen and all the rest.
No, they failed. Okay, that's our challenge to the legislation. We're saying that there's too many inconsistencies in here. Okay, the Road Safety Act denies our freedom of movement under Section 92 of the Constitution. Okay, so what we need to do though, before we get to that point where we're starting to talk about the alleged offence that the prosecutor has us in there for, we must establish that the arena that we are in to argue with our neighbour complies with the law. Okay? Otherwise, they will just railroad you on what's called prima facie evidence. Okay? Ian?
When you first go to court, you've got to sign the forms. How should we sign that? As agents with a corporate name or not sign it?
I've never had to sign any paperwork before going to court. If they're doing that now, I would put under duress.
I've got one of those stamps that, you know, you name some capital letters and then as agent and then you write your name lowercase so that you...
No, I would just put under duress. Okay? Just under duress, because they are putting you into another jurisdiction. Okay? When you put under duress, that's your common law right to say that I'm under pressure here, so I'll do this, but. Okay?
There was another
Yeah.
thing in the Constitution covering Clause 5, which is very good about the judiciary and how it applies to all.
Yeah, absolutely. You want to read it out?
That's also very good.
Yeah, binding. So this is binding on every person, including all the judges, covering Clause 5 of our Constitution.
All judges and every person.
All judges and every person of every state. Okay, this is binding. So, Section 71 establishes that all courts are under federal jurisdiction.
Daryl, there's the royal prerogative up on the screen now.
Beautiful. Royal prerogative, Halsbury's Laws of England, 3rd edition. Okay, the 3rd edition is, what, over 100 years old?
No, it's up to 1960.
Oh, 1960, but it's fair income. Halsbury's got corrupted in the 4th and 5th edition. The Crown in relation to the law, sovereignty as a source of all justice. By virtue of the prerogative, the sovereign is the source and fountain of justice, and all jurisdiction derives from her. That's why when we walk into any courtroom, there should be a photograph of our monarch on the wall.
Instead of the Queen of Pentacles from the bloody tarot cards.
Yes.
What you got in Victoria.
If you have a look at the county court, it's got the witches thing on the front of the building.
You can get one free from any federal member's office.
Yes, and Ivan was kind enough at the Darnham meeting to give Peter and I a copy of the picture of our Queen.
We're thinking of putting it on the door of our car.
Yeah. Yeah, good idea, but yeah, that's one way to empty the room, I guess. By the ancient charters and statutes confirming the liberties of the subject, the sovereign is bound to cause law and justice in mercy to be administered in all judgments. This is, however, a purely impersonal conception, for the sovereign cannot personally execute any office relating to the administration of justice, nor effect an arrest, and though all criminal suits must be brought in the sovereign's name, she could not be non-suited either in criminal or civil proceedings.